Just give me a moment as it is loading. Right, there we are. So I want to look at disciplinary procedures, and I'm also going to touch a bit on SI 15 of 2006. SI 15 of 2006, it is also referred to as the National Code of Conduct. You know, this is the Code of Conduct. This is the tool that we use for discipline in the workplace. So we are also going to be referring to that. At the end, I'm going to look at the offenses that are found in SI 15 of 2006, which you should guard and make sure you also understand. Right, let's start off by the question, which the first slide that had already come up. Why discipline? So when you talk of discipline, why is it important for us to know discipline? Now, discipline and cooperation on part of employees and management is essential to the achievement of the operations. Sorry, I was doing this presentation for Zino at one time. And disciplining employees needs both tact and legal survey. If it is done poorly, it can cripple a business both financially and its reputation. The Labor Act aims to advance social justice and democracy in the workplace. Hence, our internal structures must operate accordingly and seem to be promoting such. So when you talk of discipline, it is important to ensure that you maintain consistency when you are disciplining employees. When an employee commits an offense, you must discipline him the very same way another employee committing the same offense is disciplined. Because employees will also check and look and see whether you are consistent in your disciplinary measures. All right. So it is important for us to be able to mete out discipline and use discipline properly. Now, when you look at SI 15 of 2006, it provides the machinery for careful investigation of offenses before corrective or disciplinary action is taken. Consistency and prompt action in matters concerning disciplinary hearings, and promote substantive and procedural fairness. Now, when you look at SI 15, it is a code of conduct. Let me discuss with you a code of conduct, what a code of conduct is. Now, a code of conduct, I hope all of us in our workplaces, we also have a code of conduct. This is a disciplinary tool that outlines the offenses and the relevant penalties that should be given when somebody commits that offense. So a code of conduct must outline offenses. It must say what is an offense, what type of offenses are there, and the type of discipline that should be given to that employee. Now, there are three types of codes of conduct that an employer can actually administer. One, we have the National Code of Conduct, which is SI 15 of 2006, and that is the one that we are going to be discussing today. And number two, we have what is called the Industrial Code of Conduct, and this is a code that is developed through an NEC, and it is industry specific. In other words, it is used in a particular industry. If you go to a different industry, that code will not apply to a different industry. It is industry specific. That's why it's called an Industrial Code of Conduct. And then the third code that you can use is what we call an internal code or a company code. And this is a code that is generated by a company, specific for that company. So it is company specific. Now, we can talk of the advantages of either of these, why it is good to use a company code, or why it is used to use an industrial code or to use the national code. Now, if you look at these three codes, as a company, you can choose which one you want to use. But when you select a code to use, you must then be consistent with that code. In other words, if you decide to use a company code, therefore use the company code for all employees at all times. You cannot dilly-dally between an industrial code, a national code, and a company code. Now, it is very important, since I'm talking about these three codes, it is very important for you to indicate to an employee which code you will use on that employee for discipline. And how do you tell the employee? You indicate it through the contract of employment. An employee's contract must clearly state which code you are going to use, either SI 15 of 2006 or an industrial code or a company code. Now, a lot of companies do not have internal codes. Thereby, they rest on either the industrial code or the national code, which is fine. And in fact, when you now use an industrial code, it only applies to your graded employees only. Your management, does not cover managerial employees. What that means, therefore, for your managers, you must use SI 15 of 2006. And then for your graded employees, you can use the industrial code under NEC. And you must specify on the contract of employment, if it is a manager, that you're going to use SI 15 of 2006. And if it is an employee, a graded employee, you're going to use the industrial code. Now, what is very important here also, ladies and gentlemen, is that once you use a separate code when disciplining the employee, for instance, a graded employee, in their contract, you said you're going to use an industrial code, but because you feel that the national code will better discipline the employee and you use that code, your actions will be dismissed on a technicality when it goes to court. So please make sure you use the correct code. Now, who administers discipline in the workplace? Who is responsible for discipline in the workplace? Now, in the workplace, we must constitute one of two designated bodies that can administer discipline. Either you can create or you can constitute a disciplinary committee, or you can also have a disciplinary authority. So you can either have a disciplinary committee or a disciplinary authority. What's the difference between the two? A disciplinary committee comprises of committee members. It comprises of a secretariat where you have a chairman, a secretary, and committee members. So it is more than one person. Whereas a disciplinary authority, it is one employee or one manager in the company who is delegated to administer discipline. That's the one that we call a disciplinary authority. But let's come to the most common one, the disciplinary committee. A disciplinary committee means a committee set up at the workplace or establishment composed of employer and employee representatives to preside over and decide over disciplinary cases and or worker grievances using SI 15 of 2006 or any other disciplinary code. The regulations do not provide for the exact numerical composition of the two parties. That is the employer representatives and the employee representatives. This means the parties are free to agree on the constitution of the committee. The practice is equal representation of a chairman, additional member having a casting vote in the event of an equality of votes. And by custom and practice, the chairman comes from management. So, its composition, the setup must be fair and observe accused rights to representation. Thus, employee reps must be present. Witnesses and complainants do not constitute part of the committee, and the chair shall lead proceedings in an impartial manner. So, when you're looking at a committee, a disciplinary committee, it comprises a chairman, it comprises a secretary, it comprises committee members. And there should be equal representation. In other words, the committee must have an equal number of employees and managers who can set up the disciplinary committee. And the purpose of the disciplinary committee is to administer disciplinary procedures. In other words, they conduct or they hold disciplinary hearings they investigate, they scrutinize evidence, and then they come up together with the chairman, they come up with a determination. So the disciplinary committee, it is good to have in an organization, and some practices that are there. Usually the chairman must come from the head, it must be a head of department or a manager. That is the normal practice. And usually the chairman or chairperson must not come from the department where the offense is allegedly would have taken place. In other words, the complainant cannot be the chair of a disciplinary procedure. So what it means is a chairman must not be one designated person in the whole company all the time. A good way of administering discipline is you train your heads of departments so that each of them should be able to conduct a disciplinary hearing. So that if in the event that an offense is committed in a particular department, a head of department from another department becomes the chairman and does the proceedings for that particular hearing. That is very, very important. So it's always good to have a chairman coming from a different department than the complainant. Because the complainant and the chairman, remember, the complainant usually is also either a supervisor or a manager or a head of department. They become the complainant, and then the accused becomes the defendant. Okay. So when you now have your disciplinary committee, ensure that you train your managers to be able to conduct these. So you can rotate them and they become proficient at holding these. Right, let's look at the functions. So the functions, basically, just to zoom in, it is to decide whether a complaint has been proved in light of the facts before it, and if so, to determine the appropriate sanction to be imposed. That's number one. So to come up with a determination after scrutinizing all facts. Number two, ensure the accused is accorded all his or her rights as enshrined in the Code of Conduct and the natural principles of justice, i.e. the audi alteram patent rule, which is, in other words, the right to be heard. So the committee must ensure that procedural fairness and substantive fairness is taken out, is observed, and the right to be heard. An employee must also be heard. Their side of the story must also be heard. In fact, all rights pertaining to an employee must be observed, and it is the function of the committee to be able to ensure that employees' rights are observed. So what am I saying? Employees also have a right to representation. That right must be upheld, a right to be heard, a right to mitigation, where they actually then also mitigate so that the charge can be lessened. All these rights, we are saying the committee must ensure that they are observed. So when you look at the functions of the committee then becomes in between management needs, when management needs discipline in the workplace. It needs people to do orderly things. Management needs employees to conduct themselves properly and produce. And employees also, on the other hand, they have their own rights. And these employees' rights must be observed. So the function of the committee is to bring a balance between management needs and employee rights, where management needs are met, but without violating employee rights. Right. Let's look at the role of the secretary. I've brought up the role of the secretary because I think it's important, and who should be the secretary. Now, when you look at disciplinary procedures, we said there should be a chairman who conducts or who superintends the proceedings in a hearing. They are the ones who conduct, they are the chief officer in a hearing. But there's also the secretary, which is now, normally we suggest that this becomes HR. Human resources and HR officer must not be the chairman of a disciplinary committee. Why? Because HR must be able to advise both the employer and the employee. HR must be in a position which is neutral, where an employee can come and seek advice from HR, just the same way management should come and seek advice from HR in terms of the proper procedures that should be followed. Remember, HR, they are the stewards of the Labor Act. They interpret the Labor Act, they interpret the CBA, they interpret the Code of Conduct. So they should be neutral. What are the purposes? They should prepare the file, i.e. adequate documentation, and have it ready for the presiding officer and worker representatives in the hearing. And also to ensure that adequate notice is given and it reaches the accused. Remember, when an employee commits an offense, normally we suspend the employee pending an investigation, and a hearing must be conducted within 14 days of the offense being committed. So what that means is HR has the role to communicate, 1, the suspension, 2, the date of the hearing. And remember, the date of the hearing, an accused must be given 3 working days notice of the hearing. You know, I've seen people who neglect the prescribed times, which is 14 days for suspension. And then they only remember that, oh, 14 days is coming up tomorrow. They then call the employee to say, tomorrow, come in for your hearing. An employee can contest that. Why? Because an employee must have enough time to build their case and to be able to defend themselves. So an employer or the HR must notify the accused within 3 working days before the actual hearing. And the notification must also include a copy of the charge which the employee is being charged with. You can even give them the charge sheet, if you so wish, so that the employee knows exactly the charge, they know the offense that they are being charged with, and they can now build their own defense, come up with witnesses and so forth, so that they're able to defend themselves. So all this should be done through HR. So they should also give adequate notice. They must capture the proceedings without bias. You see, that's why HR should never be the chairman, because HR must also then record the proceedings. You can use a recording device, but you need to seek consent and notification and notify all parties involved that the meeting is going to be recorded, but the recording cannot be used as evidence. The recording can only be used for the generation of the proceedings so that they can be captured on paper. All right. And then advice on the obvious legal issues to be observed where they seem to be ignored. Adherence to company policy and procedures. Remember, HR is the steward of these. And also to ensure that documents that may be needed are readily available, e.g. the disciplinary records, etc. And communicate the outcomes to all that are concerned. That's the role of the secretary in a disciplinary committee. And I think that is very, very important for HR to take up that role. Now, what is a misconduct? Because when you now look at discipline, you want to discipline an employee on an offense. In other words, what is an offense? What is a misconduct? So when you look at a misconduct, number 1, it is a violation of employment expectations. That's number 1. Number 2, failure to follow a law, a rule, a regulation, a policy directive, an instruction, or an order. That's number 2. So if you fail to follow a law, a rule, a regulation, a policy directive, instruction, or order, what it therefore means is an employee must be well aware of the law, well aware of rules, regulations, and policy. You know, now, if you come to this one, especially when it comes to induction, a lot of companies do not induct their employees properly. In other words, they do not give them adequate information as to the policies that are existing within the organization, such that sometimes employees commit offenses without knowing. And sometimes they don't even know the repercussions of the offenses that they are committing. Because as HR, we are not taking enough time to discuss with our employees. So it is important to ensure that at induction, an employee is given the HR policy to read. They are given the code of conduct to read so that they know the offenses. And they must sign somewhere to acknowledge that they have, number one, read, and number two, they've understood the policies and procedures that are within the organization. And misconduct is also, it is conscious, deliberate, and within the employee's control. In other words, the employee, by their own volition, decide to commit the offense. So when an offense is then committed, the proper procedure is you suspend the employee, and then within 14 days, you hold a hearing. Who conducts the hearing? The chairman of the disciplinary committee, together with his committee members. And then the employee or the accused should then come up with their defense. They can be represented, and the complainant, being the other HOD where the offense has been committed, then also presents facts. And when you look at disciplinary procedures, we do not use the principle beyond reasonable doubt. We use what you call balance of probabilities. Is it probable that the employee has done this? Is the evidence pointing to the fear fact that it is most probable that the employee committed that offense? So ensure that all evidence is provided in the hearing so that employees can understand the charge, and the evidence must point to either the fact that the employee committed the offense or the employee did not commit that offense. Now, the offenses that I want to look at very quickly before I come to the end of my presentation and maybe open up for discussion are the offenses that are enshrined in SI 15 of 2006. So when you are now creating the charge sheet where you are charging the employee, if you are using SI 15 of 2006, there are 8 offenses that are enshrined in that SI. And they are found in section 4 of the SI. So there's 4A, which is the first one: any act of conduct or omission inconsistent with the fulfillment of the express or implied conditions of his or her contract of employment. That's the first one. So here we are saying the employee has had a conduct or an omission which is inconsistent with the fulfillment of the expressed conditions. By expressed conditions, these are conditions of employment that are written down. They could be in an HR policy. For instance, it could be dress, it could be conduct, it could be this. All those that are written down, that's your expressed conditions of employment. Or implied, there are certain things that are not written, but are assumed that they are, it's natural that it should be done. For instance, coming to work, you may not write a dress code for your employees, but it is assumed that you do not come to work wearing slacks or shoe, or what do you call them, mapusha. You don't wear those, but you come wearing modest clothing. Or it may not be written that in the workplace you must not use vulgar language, but it is implied, it is known that good conduct, you should restrain yourself from the language that you use in the work environment. So if you then start to use vulgar language, where you are now being rude and unruly, even if it is not written down, it is an implied condition of employment. And therefore, this particular offense covers all those kind of things. So this one covers quite a broad, quite a big, a huge number of offenses. For instance, if an employee wearing your uniform, your company uniform, branding, and so forth, they go and start fighting with other people out there in the public, and they destroy, they damage property, and videos are taken, they're flighted on social media where the employee wearing your company regalia beats up somebody, damages things. Now, obviously, in your contract of employment, there's nowhere where it is written that you should not fight other nationals in Zimbabwe. No, there's nothing like that. But that conduct is inconsistent with what we would expect you to do whilst you're wearing company regalia. So we can actually charge you. And by the way, these 8 offenses that I'm discussing with you, they are dismissible offenses. What that means is, if an employee commits any of the 8 that I'm going to be mentioning now, they are dismissible offenses, unless the employer wants to be lenient. And the first one, there's a case there which you can also look up, which is Geddes Private Limited versus Bwanya. And there's also Trigger Plastics versus Sibanda and Magondo. Those are some cases that you can also look at when it comes to conduct that is inconsistent with the fulfillment of the expressed or implied condition of employment. 4B, there is willful disobedience to a lawful order. Now we've got a very common word that we use for this one, which is insubordination. Now, if an employee is insubordinate, they can also be charged. Why? Because a contract of employment is subordinate in nature. An employee subordinates themselves to the employer, to the conditions set within an organization. And if the employee is not subordinate, they can be charged. So willful disobedience to a lawful order, basically, we are simply saying the employer has given an employee a direct order in what they are supposed to do, and then the employee, within their own conscience, within their own rights, within their own volition, and not under duress, they decide not to follow that order. It is a dismissible offense. You can see ZCTU versus Makonese, Zim Alloys versus Mchohanyi. You can also see that one as well. That's the second offense, willful disobedience to a lawful order. 4C, willful and unlawful destruction of the employer's property, that we call vandalism. Vandalism is an offense which is dismissible according to SI 15 of 2006. So if employees, maybe they are in a protest and they destroy company property, again, the term here is willful. In other words, it is direct, it is intentional. If it is an accident, that is not willful. But if it is intentional, then it becomes willful, and it is a dismissible offense. 4D, theft and fraud. Now with theft, there can be theft by conversion, where an employee, if they receive money for the organization on behalf of the organization, and then they convert that money to personal use, that is theft by conversion. And fraud, you can look at coming up with fraudulent documents, fraudulent signatures, and all sorts. Those are also dismissible offenses. And you can see Zesa versus Dera, Standard Chartered Bank versus Chapuka. These are also, you can go and Google these, you can see those as well. And here's another one, 4E, which is now number 5. Absence from work for a period of 5 or more working days without leave or reasonable cause in 1 year. Wow. This is the one that we call AWOL. And an employee must notify an employer if they are not coming to work. If they are unable to come to work, they must notify. It is the employee's obligation to notify the employer that they are actually not going to be attending work, and they can apply for leave. Now, failure to notify the employer and failure to take any leave for 5 or more days, then it becomes a dismissible offense. And employees can be dismissed based on that. And there's more versus Beverly Building Society, Kotko versus Mchira Hondo, and Mwanyisa versus Ministry of Finance. You can also have a look at those. And then F, gross incompetence or inefficiency in the performance of his or her work. Now, here when you look at gross incompetence, incompetence on its own is not a dismissible offense. In fact, incompetence, it is a training indicator. It is grounds for training. If somebody is incompetent in a particular area, send them for training so that they become competent in that area. Okay. So incompetence on its own, it's not an offense. However, when it becomes gross, that's when it becomes a dismissible offense. Now, what we mean by gross, we are saying that the employer has suffered some financial loss due to the incompetence. That's when it then becomes gross, or due to the inefficiency in the performance of the employee's work. So when you now look at gross, when you now want to charge an employee using gross incompetence, you must have quantifiable losses that the employer or the company has incurred because of the incompetencies of the employee, so that you can now bring out the gross aspect. Okay. And the Zim Mining and Smelting Company versus Mafuku, Quest Motor Corporation versus Nyamafuku, Dube versus Standard Bank, ZB versus Kuda Mafunga. You can also look at those classical cases. And then G, habitual and substantial neglect of his or her duties. Now, when you look at habitual and substantial neglect, first of all, the word habitual is coming from the root word habit. And for a human being to develop a habit, it has been scientifically proven that it takes 21 days for somebody to develop a habit. So what am I saying? When you look at the habitual, we are saying it is not a single event. It is something that has been repeated over a period of time, whereby we can now say that this is the employee's habit. It is habitual. And then when we say substantial, we are saying that there is also a financial loss because the employee neglected his or her duties. So when you're charging an employee with this one, you need to ensure that you also bring out, number one, the aspect that it is not the first time the employee has done this, so that we prove the point of it being a habit. And then number two, it is substantial in the sense that there has been a financial loss, there's been a damage to the employer's reputation, or there's been a loss of clients, there's been a loss of clients where we've lost some clients due to the neglect of the employee's duties. You can also then look at that as habitual and substantial neglect of his or her duties. And there's Zimasco versus Banda. You can also look at that one. And then 4H, we're saying lack of skill, which the employee expressly or impliedly held himself or herself to possess. Now, with this one, this is an offense where an employee forges certificates, forges the skills that they say they have in order for them to secure a placement or a job. And only after they have now been recruited and then they are supposed to work, it is then discovered that the skills that they said they had in their CV and the skills that they purported to have in the interview, they do not have those. And when you do further investigation, you go to check the educational institutions and you find that the employee never attended anything in those institutions, meaning that the certificates that they presented are fake. we are saying that you then use this as the basis of the offense, where the employee does not have the skill. An employee must always be honest when they are in an interview. They must also be honest on their curriculum vitae, which they then send to people. And there is Total versus Moyana, Makina versus State, GMB versus Pangeti. You can also have a look at these cases so you can also understand how these also work. All right. So these are the 8 offenses which I wanted to discuss with you this morning. And when you now have these, I've selected these 8 because they are coming directly from the SI 15 of 2006. And you can use these if you are disciplining your employees. If any of your employees actually they do any of these offenses, or they are alleged, or the fact point that they've done this, you can then also then charge the employees with these ones, and you can terminate the employee's contract of employment. Now, after you have charged the employee, after you have looked at the evidence, if the evidence shows that it is probable that the employee committed the offense, the committee must then get into a process called mitigation with the accused. Now, with mitigation, basically, we are simply saying we are affording the employee an opportunity to tell us why, or tell the committee why they did the offense, or if there are any facts that can help lessen the charge. Because remember, this is a dismissible offense if we look at SI 15. So we give the employee an opportunity to defend themselves. They can say, look at my track record. I've been with the organization for 15 years. I've never committed this. I was under pressure. That's mitigation. So the committee must take note of that. They can also take note of him being a first offender, take note of him or her being a breadwinner, to say, well, if my job ends, my family is going to be in dire straits. Why? Because I am the breadwinner. My children are still in school. Please, can you lessen my charge? That is called mitigation. And it is always important that after a disciplinary hearing, before you conclude the matter, you must give the employee an opportunity for mitigation. Now, proper procedure is usually after you have seen all the facts and you've come up with a determination, you can inform the employee that this is the position. What are your mitigating factors? They can give you mitigating factors, and as a committee, you can either lessen the charge or drop the charge. It now becomes the prerogative of the committee. But not only do we have mitigating procedures or mitigating factors, we can also have the direct opposite, which is aggravating factors as well. And by aggravating factors, we are saying these are now factors that increase the weight of the offense. So aggravating factors can include things such as they have done this before. It's not the first time. 1, 2. Aggravating factors can also include the damage of reputation to the employer, significant losses to the employer in terms of financial losses, and so forth and so on. All of that, it can become aggravating. Or even the attitude of the employee, or the conduct of the employee, where the employee intimidated witnesses. The employee waited for witnesses at the gate outside the premise so that they can intimidate. Those are aggravating factors. And therefore, you also look at those and then come up with the final determination, which must be given to an employee. Ladies and gentlemen, these are the issues that I wanted to discuss with you. And remember, the reason why we're looking at these procedures, I was just taking a few, there's a lot that we could have talked about, but I just wanted to discuss in a nutshell some of these things so that we are able to also appreciate and know some of these procedures. At this particular juncture, let me open up the floor. If there are any people who would also like to contribute and ask questions, you can unmute yourself and you can ask your question.
Thank you very much for the presentation. I just want to take us back to the point you were talking about implied conditions of service. I felt that it was a bit, while it's a statutory instrument, it is a bit shady and subjective when it's implied and open to argument because people then is there any way we can safeguard it from not being all over the place but being confined to a particular charge? I hope you are understanding what I mean, because if you say it's implied, it's not overt, it's not out there, so how can we ratify something that is implied?
Okay. All right. Thanks for that. Now, with implied, definitely, yes, it can be open to abuse. That's very true. But you also find that the spirit in which it was brought in was that sometimes you may not have something really written down, but you can tell that this is an offense, but it's not written down, and it should then be able to be brought to charge. Now, normally we should not fear that abuse is going to be all over the place. Why? Because the committee is the one that should then regulate. Remember, we're looking at the balance of probabilities. Is it really probable that the employee actually did this? So yes, a charge can be brought, but if, in all fairness, a disciplinary committee with a right constitution, they should be able to dismiss a charge. Because once a charge is brought, it doesn't mean it's always going to stick. A charge can be brought, but if there are no adequate facts to back up that charge should be brought down. So anyway,